No, sir.
What?
You are in custody right now. If you leave the courtroom, it's a felony escape.
That's a felony to put me in custody because you have no authority or jurisdiction or standing.
All right, everyone. Today we're looking at one of the most intense court hearings I've seen in a long time. This case involves a self-identified sovereign citizen who refused to turn himself in after a warrant was issued for his arrest. What makes this hearing so unusual is that the defendant claims he doesn't legally exist at all. I also want to apologize for the video quality, but trust me, this case is worth watching. Let me know what you think about the arguments being made here, and if you enjoy unpredictable courtroom moments like this, be sure to like and subscribe. Let's get into it.
Okay, so you failed to appear for court multiple times in this case.
Your Honor, just for the record, the named defendant is actual property, a registered trade name. And the case has also been certified as a fraud. I have court certified documents to prove that. That should be on the record. And that's the reason why it was certified to be a fraud, because the plaintiff is a foreign-owned private corporation, of which I have no contract with, and neither does the registered trade name. And the registered trade name has been used without authorization and permission, and there's an act of identity theft. And that's probably one of the reasons also why the state has acquiesced that both cases are a fraud. Let me add one more piece of information. I am a foreign sovereign with respect to the privately owned foreign corporation known as the state of Washington.
Yes, on the 303 matter, Mr. Haywood was sentenced to serve 4 days in jail. He failed to report to the jail on June 29, 2023, and we're asking him to be taken into custody to serve that time.
Objection, Your Honor. I actually contacted the jail to make special arrangements to deliver the defendant with the special arrangements to not damage the paper, and the jail refused. So I attempted to deliver the defendant, and objection, the state has no standing as they are representing a privately owned foreign corporation, and the prosecutor is not licensed to practice law.
So here's what the defendant is arguing. He says he went to the jail with a piece of paper that had his name on it and believed that handing over that paper counted as surrendering on the warrant. He seemed to think that simply presenting this document was enough for law enforcement to take him into custody. Unsurprisingly, the jail did not accept it, because a piece of paper isn't a legal substitute for following arrest procedures. It's honestly hard to tell whether he truly believes this logic or if he's deliberately leaning into it for attention. I've seen many sovereign citizen cases before, but this one definitely stands out. Let me know what you think so far, and let's continue.
Okay, so I think it's the 303 that he was convicted and ordered to do jail, and you believe that he didn't comply with jail because there's a docket entry that said defendant complied with jail. Maybe that was an error.
That was probably my attempt to deliver the defendant to the jail, but they refused. And just to clarify, the defendant only exists on paper, just as the plaintiff only exists on paper. The jail refused the paper, and here we are today. And the state still hasn't proven standing yet, by the way, as well.
So, Mr. Haywood, it doesn't look like you did the sentence on the 303 matter. And so I am going to quash the warrant. However, I am going to have you serve that time.
Okay, well, I'll deliver the paperwork to the jail. That's fine. I tried to once before, but they refused it. And just to clarify, I'm not the defendant. There is nothing on there, nor is there any testimony from anybody as first-hand witnesses under penalty of perjury that I am the defendant. And I've uploaded plenty of documentation to prove I'm not the actual defendant. That is a registered trade name, matter of public record, and registered with the state. So if you want me to serve some jail time, then we're going to need to change who the defendant is, because I'm not the defendant.
All right. So can you upload a new commitment?
Yes, Your Honor.
And the reason they couldn't put my name on there as a defendant is because I'm a foreign sovereign with respect to the corporate entity known as the state of Washington, of which I have no contract with.
Well, you had your day in court on the 303 matter. You had a trial. You represented yourself or the defendant, whichever way you want to say it, but you represented the defendant yourself. And you were convicted and you were ordered to serve 4 days in jail. You didn't do that. And so
The defendant was ordered to serve 4 days in jail, and I attempted to deliver the defendant to the jail, but the jail refused.
okay, well, I'm going to make sure that they don't, because I've done a new commitment for you today so that they won't refuse for the defendant to serve that time. You're going to serve those 4 days and then you'll be released, and nothing more will happen on that 303 case. You'll be done. And then this case will be heard August 24th at 10:30 in the morning. If you change your mind about representing yourself, then you can ask for help if you want it. If you don't want help, we don't have to have it. So we'll see you in August. I'm going to have you take a seat right over there.
I won't be here for the defendant August 24th. Would you like me to deliver the defendant to the jail?
I would like you to sit over there. Go take a seat.
Okay, so let the record reflect no jurisdiction has been proven.
At this point, the behavior in the courtroom becomes overwhelming. The defendant repeatedly interrupts the judge, challenges the court's authority, and refuses to acknowledge his legal identity. He even states that he doesn't recognize the name the court is using for him. Situations like this raise an important question. How much patience should a judge show before taking stronger action? Some viewers might feel the judge should step in more firmly, while others may see this as one of those hearings where the best approach is to let the record speak for itself. What do you think? Let's move on.
Sonia Sesko, customer 2310242. Mr. Haywood, sit down.
Am I obligated to follow these rules?
You are going to sit down right now.
Do you have any jurisdiction? I don't believe you have any jurisdiction that's been proven yet.
Please sit down.
Are you threatening me with violence?
I'm asking you to sit down. Sit down.
You only have authority over the defendant. You have no authority.
What are you doing?
Mr. Haywood?
You escaping?
I got things to do.
No, sir.
What?
You are in custody right now. If you leave the courtroom, it's a felony escape.
That's a felony to put me in custody because you have no authority or jurisdiction or standing. You got some proof of that?
Okay, well, we are all being recorded, so if you leave this courtroom, it'll be a felony escape charge. Your choice.
Okay, well then, I guess in the best interest of peace, in regards to your violence, I will go ahead and relax for a minute, but let's get with it. I got things to do. Got it?
What was that just thrown?
Car keys.
Do you know that person?
Yeah, they're my boys.
Okay. All right. So thank you. Mr. Haywood has been very disruptive. He tried to leave the courtroom once he was placed in custody. So just
Put into custody, please. I just need to see the name. I just need to see the name of the person. Okay, that's not me. That's the problem here.
Our Sanborn's matter. We're here today on
That's not me. The name is same, but that's my registered trade name. I got all that documentation right here.
Okay, good. We're going to take care of it.
Okay. Yeah. Well, this is the defendant, technically.
If you want that, I can go when you put everything private.
hold on 1 second. Well, that's taken care of.
We can see that when we get the right name.
Did she file a notice of appearance?
I will make sure that she does, Your Honor.
Okay. Yeah, sorry, I haven't had enough coffee yet today. So yeah, no, you've got Ms. Bradshaw, so that's fine. You don't need to do those forms. But she does need to file.
Eventually, the situation reaches a breaking point. The defendant continues using well-known sovereign citizen arguments, insisting that laws don't apply to him because he doesn't recognize the system. This line of thinking comes up often in these cases, usually learned from online forums or videos promoting these ideas. The problem is, courts don't operate on personal beliefs about the law. Claiming immunity doesn't make legal obligations disappear. It usually makes things worse. In many cases like this, the issue could have been resolved with a minor penalty early on. Instead, refusing to cooperate leads to arrest, frustration, and more serious consequences. That's why these hearings can be difficult to watch. Now, I'm curious what you think. Is this defendant truly convinced by these arguments, or is he intentionally playing the role of a sovereign citizen? Share your thoughts in the comments. And if you enjoy dramatic courtroom moments like this, don't forget to like and subscribe. Thanks so much for watching and take care.